Thank you so much, Dominic, for that very insightful presentation. We would now move on to our first evidence session for today. And for that, I would please like to call upon Mr. Ben Theron, the CEO of OUTA, Organization Undoing Tax Abuse, and I hand over to Advocate Francis Hobden.
Madam Evidence Leader, just remember to reach a convenient point at 10:45, right?
Thank you, Chair. That will be in 10 minutes. Perhaps I can say a few things now, and we'll see, when we reach that point, we'll break for tea, if that's convenient. Today, the first witness for the state capture section will be Mr. Ben Theron from OUTA, and he will be talking about a particular example of state capture and the corruption within Denel, South Africa's state-owned enterprise operating within the arms industry. I would like to highlight to the panel that Mr. Theron will be presenting a range of documentary evidence gathered by OUTA as part of its work and part of the litigation that it is involved in. These documents have been made available to the panel. In particular, the panel has been provided with a copy of an affidavit by Mr. Theron in the litigation between OUTA and Mr. Mantash. The factual allegations regarding the VR laser deal are contained in that affidavit, and that evidence is on oath, even though the evidence that Mr. Theron is giving today will not be on oath. We will also be relying on an affidavit by Mr. Longisa Fozile, the DG of the Department of National Treasury, that was deposed to in the litigation between Denel and Treasury in May this year. That evidence is also on oath. That affidavit attaches a number of documents which are confirmed as authentic by Mr. Fozile. The other documents presented and referred to by Mr. Theron are public or official documents, statements by Denel or state departments in the public domain. And the final category of documents are documents that have been provided to OUTA, and Mr. Theron will talk about these documents a bit further during his presentation. But to note that Mr. Theron cannot testify as to the authenticity or truth of these documents that have been provided to OUTA. However, we invite the panel to make a finding that cumulatively, all the documents presented by Mr. Theron create a prima facie case that important decisions of Denel were being directed by private third parties to further their own interests. I'm also going to note to the panel that the organizing committee of the tribunal approached a number of people with direct and personal knowledge of the events that Mr. Theron will speak about this morning. All of those people have declined to come and appear before the tribunal. The organizing committee can make the names of those people approached available to the panel, but we will not be publicly naming them at the moment.
We can't pretend to be surprised.
The panel has heard evidence yesterday about the difficulty of the difficult position that whistleblowers find themselves in both public and private sector corruption. So with those introductory remarks in mind, we will begin with the presentation by Mr. Ben Theron. Mr. Theron, thank you for joining us. Could you please tell us your qualifications and experience, your role in OUTA, and the work OUTA has been doing with regards to the Denel and VR laser transaction?
Thank you. Good morning, everybody. My name is Ben Theron. I'm the Chief Operating Officer of OUTA. I started working there 14 months ago, and for the last...
Microphone and a bit more slowly.
My name is Ben Theron, Chief Operating Officer for OUTA, organization doing undoing tax abuse. I've been there for the last 14 months, and in March, April last year, we started getting information about state capture, the rot and the problems that face civil society with abuse taking place at government level. And the further we investigated, the deeper the rot became apparent. In particular, over the last year, a lot of information came out regarding the Gupta family and their role that they've played. Bear in mind that the Gupta family is only one portion, and this corruption in South Africa started way before them. As we move forward, we are now preparing to actually fact participate in the state capture inquiry. In June last year, we presented a document to Parliament called President Caught in the Act, No Room to Hide. And that was just before the vote of no confidence started, shortly after that. We've been involved in identifying, trying to identify the people involved in corruption, and by laying charges against those. Because somewhere we knew that we would turn, and the criminal justice system would then start acting and doing what they're supposed to be doing. So since July last year, we've laid a significant number of charges, of which one of them would be against Mr. Mancha, and we'll talk to him about later. Denel is, and in the presentation, you'll see that there's a trigger that happened in 2011 when the Gupta family realized there's a trove of money available, and they started investing, and one of them was Denel. And a key component of that would have been the VR laser deal, and I'll cover that now. I'm not too sure whether, is the bullet presentation be shown, or should we just continue? In 24th of July 2015, a new board was appointed by Minister Lynn Brown. She commended the outgoing board for their hard work, and in fact, putting Denel on a stable footing for growth. Denel Mancha was appointed as a non-executive director and chairperson of the board. The rest of the board was new, except Mr. Johannes Motseki. What you see on the board as I go on is there are two portions. You'll find two portions on every slide. On the one hand is the one I'm talking to, and on the right you'll find a little bit of the, just a snapshot of the evidence that I have available on that. I have provided a stick with all that evidence, so it is really available on soft copy for later reference. The reality of the new board is the operational expenses went up from 939 million to 1.4 billion rand. The net profit increased from 270 million in 2015 to 395 million in 2016, but then significantly decreased to 333 million in 2017. When measured against operational expenses, Denel was in a financial downward spiral. The reality of the new board. Mr. Johannes Motseki was the only one that came through from the old board. He was involved with the Gupta family in 2010, so he's got a long history with him. Mr. Motseki's company, of which he was the sole director, was allocated 1.3% in the Gupta-owned Shiva uranium. And uranium was one of those things being prepared for at the time for the nuclear deal. There was a lot of information that's going to come through, and therefore they started investing into those. Gupta sponsored a trip to Mumbai and Delhi in 2010. As treasurer of the MK Veteran Association, he facilitated a donation of 850,000 from the Guptas to fund a conference. The list of the new board members was not the original list prepared by the DPE. So typically what happens is the Department of Public Enterprises would go out into the market, find suitable people, do research on them, making sure that they are people of good reputation, they've got the experience, etc. The list that they prepared differed significantly to the list that was presented by the minister to the cabinet for approval. There was no, for example, there was not one single engineer on the Denel board, and Denel is a very technical organization. The chairperson appointed, Mr. Daniel Mancha, raised many questions. Let's talk about Mr. Mancha. Shortly after his appointment, Mr. Mancha suspended the following Denel employees: the CEO, Mr. Rihaz Soluji, the CFO, Fikile Monklonto, and the company secretary, Mrs. Elizabeth Africa. No formal reasons were given for this. Subsequent charges were spurious and questionable. There was a strong suspicion that the three company managers were suspended to make way for the Denel VR Laser Asia deal.
Mr. Theron, can I stop you there? We will be breaking for tea shortly, but before that, you've mentioned that Minister Lynn Brown replaced the board of Denel. What reasons were given publicly for replacing the whole board, save one board member?
I don't have the information really at my fingertips. I can provide it
I
to
think
you.
I'm referring to the statement made by the department where the minister sets out that a new board is being appointed and congratulates and as you mentioned, thanks the board, and then goes on to appoint a new board. And I'm asking if in your work that you've done, there are any other reasons you know of or have seen why there was a replacement of the board?
There's a trend that happens through all the state-owned entities. A new minister gets appointed, they replace potentially the DG of the organization as well as the boards. Because what happens is the people they place into boards are ignorant, poorly equipped to do the job, and in fact very soft. So they don't have the backbone to say no to things. And typically what happened in Denel, and much more obvious nowadays would be the ESCOM board, which is very similar to that, is where you put poorly qualified people in that actually just do what they are told. And this is particularly what happened in the Denel.
So in your opinion, there was no good reason or no rational reason that you've seen in the work you've done for the full replacement of this board with the new board members?
They were doing excellent work, the old board. They were commended for the work they did. There was no logical reason.
Thank you. And I think with that response, it's now 10:45, and I believe the panel would like us to break for tea at this point.
Right. Thank you very much. We'll be back in half an hour.
With the evidence of Mr. Ben Theron from OUTA in relation to state capture. Mr. Theron was presenting evidence earlier regarding the replacement of the board of Denel by Minister Lynn Brown. And I've asked Mr. Theron to have a look at the statement issued by the Department of Public Enterprises regarding the appointment of the new board of directors. And in that statement, it's in the pack provided to the panel, it's SF1. In that statement, there is a list of the new directors. And Mr. Theron, I'd like you to have a look at that statement and confirm, do any of the new directors have PhDs?
None of them have.
And do any of the new directors have any engineering qualifications?
None of them have.
And do any of the new appointments, have they previously been directors at Denel or an arms company in the industry?
The new ones, no.
Now, I'd like to refer to a document now that's a public document. It's not before Mr. Theron, but I just want to point out that the board prior to the 2015 replacements, out of those board members, 2 of them had PhD degrees and 2 of them were qualified engineers. And 4 of them had been appointed to the board for more than 4 years. And in particular, the chairperson of the board at that stage, Ms. Martie Janse van Rensburg, had been appointed to the board in August 2010 and had been appointed as the interim chairperson of the board in 2014 and was currently holding that position. And I would just like to contrast that to the new appointees. But with that point made, Mr. Theron, you can continue with your evidence, moving on to a discussion of the qualifications and links of the new chairperson of the board with the Gupta network.
Thank you. I want to move on to Daniel Mancha, the chair. And I just want to introduce the topic of him very specifically about the Gupta leaks and the veracity of the information, etc. The evidence we used, and we have used in other cases, were obtained from an email server of Sahara Computers that shows improper relationship between Mr. Daniel Mancha and the Guptas. The improper relation was fully investigated by us, and OUTA laid charges against Mr. Mancha in September 2017. And as I said in my opening remarks, hopefully soon the criminal justice system will start acting against those people involved and affected by corruption. Dan Mancha corruption and fraud charges. Mr. Mancha is an attorney, obtained a B. Juris in 1991 and LLB in 1993, both from the University of Venda. He is currently the director of Lungisani Denel Attorneys and Lungisani Management. He became non-executive director and chairperson of the Denel board in July 2015, and he served as Minister Faith Mutambe's legal advisor, Department of Communications at the time. Mancha was struck from the role of practicing attorneys in 2007 for abusing the trust funds. He was readmitted in 2011 and up to date, and we've done significant research in this regard. We cannot find any documentation, court or even at the Law Society of Johannesburg, for the paperwork and the administrative side of those things to get him reinstated as a lawyer. Let me just make a comment or two about the authenticity of the Gupta leaks. OUTA obtained the Gupta leaks on 30th of May 2017. The hard drive was delivered anonymously to our officers, so we don't know the source of it. But the authenticity of the mails were analyzed by a qualified, internationally recognized cyber forensic team. The authenticity of the mails was confirmed through an analysis of metadata in the email headers. The authenticity of all hard drive contents will be tested in court. And until that time, we regard them as credible, but once it's contested in court and discussed in court and then confirmed, it will then become legal documentation going forward. Now I want to move on to the timeline of activities in terms of evidence. On the 3rd, and what happens here is just the way Daniel Mancha was manipulated. He abused and used the Guptas to his own ends. And the next few things are just very specific instances where he got flown to Dubai, flown to India, and this was a precursor to the VR laser deal that then subsequently appeared. On the 3rd of August 2015, Ashu Chola applies for a 3-month tourist visa for Mancha. The visa application clearly shows that the Guptas are planning to take Mancha on trips to Dubai and India, presumably to promote the Denel Asia plans. Bear in mind that this is now a chairman of a state-owned entity, and if you're a public servant, there are processes internal that you can follow to pay. If somebody else pays for your trip, it is regarded as irregular. It is frowned upon because that opens yourself up to abuse and manipulation and corruption. And therefore, there are certain very strict rules when it comes to overseas travel. On the 3rd of August, Mancha office, info@Lugisani Mancha attorneys, sends an email to Ashut Chola with a copy of municipal account attached. The message in the mail reads, "For urgent attention." In other instances that we found in the leaks, normal people in civil service actually used the Guptas as a purse, as a kitty. So there were instances where people ran out of airtime. It's as ridiculous as this. People don't have airtime, so they send a WhatsApp, "We need 300 Rand just for airtime." Somebody got stuck on the way to Sun City, and he required 3,000 Rand just to get, because his wallet was stolen, so he asked them the thing. The president's son, Duduzane, was involved in an accident where a lady got killed. And the first person he called was exactly the Gupta brother, one of the Gupta brothers. So the Gupta brothers have become actual fact support system for individuals in the state environment. On the 6th of August, Mancha was flown to India in the Gupta jet, ZS Oak, and I think ZS Oak has become common knowledge in our day-to-day running. He was accompanied on this flight by Mrs. Anguri Gupta, Mr. Rajesh Tony Gupta, Mr. Arti Gupta, Shashank Singala, Aman Khan Sangala, Salim Essa, and the Gupta bodyguard, Mr. Gijsberg van der Berg. Mancha was a passenger on the Gupta-owned ZS Oak that flew back from India, Mumbai, Delhi, to South Africa on the 9th of August, 2015. On the 6th to the 8th of August, Mancha stayed at the club ITC in India. The invoice is made out to Mr. Mancha with Sahara South address as the reference address and as reference to the SES Technology, a Gupta-owned company in India. It clearly shows that the invoice was for Sahara South African address and hence for their account. 29th of September 2015, Mancha office sends an email to Ashu Chola with a copy of the passport attached. Ashu Chola sent the copy of Mancha's passport to Halima at Alana at Travel Excellence with an instruction to apply for a Dubai visa. Remember what I said, if you're a state employee, you've got particular protocols, and this does not conform to any of those protocols. 28th of November 2015, Mancha receives a mail from a registration from Denel. Attached to this mail is a PFMA section 54.2 pre-notification on the proposed formation of Denel Asia from Lynn Brown, Minister of Public Enterprise at the time. The letter from the minister is clearly marked confidential. This is very important because when a cabinet minister writes to a chair, that information, the communication between the two of them is regarded as sacrosanct and confidential between those two. To send this mail on to private citizens is an illegal activity. On the same day, Mancha forwarded this notification to Ashu Chola. Timeline of activities. 30th of September 2015, Travel Excellence received the Dubai visa for Daniel Mancha and forwarded to Ashu Chola and confirmed the booking for Mancha to fly back from Dubai to South Africa on 6 October 2015, and you see the boarding ticket, the electronic ticket there. On the 30th of September, Ashu Chola sent a mail to the Oberoi Hotel informing them that Mancha will be a guest there, together with Duruzana Zuma. Hours later, the Oberoi Hotel confirmed the booking for Mancha from 3rd to 9th October. Chola informs the Oberoi that Mancha will check out on the 6th of October 2015, and the Oberoi confirms that this Mancha booking has been charged as instructed. 6th of October 2015. After his stay in the Oberoi Hotel, Mancha flies back to Dubai to Oliver Tambo on flight SA7163 with a ticket booked and paid for by the Gupta company, West Dawn Investment. The amount paid for the flight ticket is 33,280 rand. 31st of October. Mancha sends a letter that was prepared and sent to the Minister of Finance to Ashu Chola. The content of the letter is Denel's PFMA section 54.2, pre-notification for the proposed formation of Denel Asia. Now remember, this is a potential partner. You do not share confidential information with somebody that you're bidding and negotiating with, and this is also irregular. On the 23rd of November, Mancha received an email from Kirumanang Mshlongo from the Department of Public Enterprises. The annex to the email was Minister Brown's response to the Denel's notification to her regarding the proposed tie-up of the Denel joint venture. The email was marked, once again, confidential, and was meant to advise the government Denel executives in the dealings with the Guptas. On the 28th of November, Mancha forwarded the confidential letter he received from the minister on 23rd to Ashu Chola. He used his law firm address to send this information to the Guptas. 3rd of January 2016, Mr. Ashu Chola confirmed travel arrangements for Mr. Mancha. Mancha was booked into the Oberoi Hotel in Dubai from 3 to 6 January 2016. Chola arranged a concierge service to Mancha to the exclusive housing estate in Dubai, L35 Emirates Hill, where the Guptas reside. Mancha arrived from OR Tambo International on the Dubai airport on flight EK786 at 19:20. During this time, 4 to 5 January, Machela Koko of Eskom also stayed at the Oberoi Hotel. Throughout the last few months, the Oberoi Hotel has become very well known and notorious for South African ministers, civil servants that have been flown to Dubai to negotiate deals for private visits, and they were all paid by the Guptas. One other name that would pop up is Minister Zwane. Let's talk about the charges that we laid what OUTA laid charges.
Sorry, may I interrupt at that point? You've provided the panel and everybody here with evidence of a number of instances that show a link between the new chairperson of Denel and the Guptas. And this is set out in your affidavit, and you're moving on now to talk to the charges that OUTA has laid. And it might be convenient now or later, but could you tell us if there has been a response, an answering affidavit in that litigation, and if so, what response or explanation has been given to explain some of this correspondence, and in particular, the forwarding of confidential correspondence from the minister to private third parties?
We've laid charges, as I said, I think in September, August. We've communicated this information to the minister, and there's been none responses whatsoever. What I've done is I've just taken a quick snapshot out of the affidavit that I've laid. On 30th of August 2017, OUTA laid criminal charges of corruption and fraud against Mr. Mancha. Mancha is a qualified attorney and served as Minister Faith Nthambi's legal advisor at the Department of Communication. So he's no stranger to the workings of civil servants. He worked with a minister, so you should understand the importance of confidentiality, how to deal with this documentation, as well as travel arrangements. With his qualification and professional experience, he should have known better than to accept favors from the Guptas. Sharing confidential documents and accepting favors from a company who wants to partner with the SOE was unethical, irregular, and in our minds, criminal. As a lawyer and a former advisor to the minister, he should have known that he was grossly violating the regulations of the PFMA. That is the essence of the charges we laid. Now can I move over to the Denel Asia joint venture? Mr. Mancha oversaw the conclusion of the Denel Asia joint venture between Denel and VR Laser Asia. VR Laser Asia is a wholly owned organization by Salim Essa. He's a known Gupta business partner. Mr. Essa has an associate company of VR Laser Services, a South African steel cutting business. West Dawn Investments, trading as JIC Mining Services, has a 25% stake in VR Laser Services, and Salim Essa has a 75% stake. Duduzani Zuma and Tony Gupta control West Dawn Investment, so the links are definitely there. VR Laser Services is registered to a Sandton office park where Gupta businesses are based. VR Laser Services has 3 directors: Salim Essa, Pushpa Veri Govender, which is the director of other Gupta companies, and Kamal Singala, who is a family member. 10 December 2015, the day after Desmond was appointed as Minister of Finance, Mancha submitted the Denel application to National Treasury for approval of the Denel Asia joint venture. The coincidence is just too good to be true. The venture was formally announced in January 2016. We believe that the reason for Desmond Royen's appointment is one of the reasons is to manipulate and to advantage the Gupta family. The joint venture was conducted by Denel without approval from the Minister of Finance or the Minister of Public Enterprises as prescribed by the public PFMA. The incentive, an allegedly a US $4 billion tender to deliver long-range artillery to the Indian Army. The terms of the deal were weighed very heavily in favor of the Guptas. Drafts of the joint venture agreement forwarded with the Gupta and Mr. Richard Chaleke, at the time the DG of the Public Enterprises, showed Denel gave up its intellectual property to Denel Asia. Now, if the intellectual property is very important because that is in fact where the value of something lies. It's not in the manufacturing, but the ownership of the intellectual property, because that is worth millions. It was done for a promise of 100 million marketing contribution from VR Laser Asia, treated as an interest-bearing shareholder loan to the company by VR Laser Asia. So as much as it sounds like a sweetener and it sounds lots of money, 100 million rand today, a few years later, we fully understand that billions of rands have been stolen from state coffers up to date. So 100 million rand is a pittance compared to that. In addition to that, that was purely just a loan and not an investment. Denel Asia proposed joint venture with an Indian investment company controlled by Anil Gupta and Andani Enterprises, allowing the Indian investment company right of first refusal to manufacture any product that Denel state-owned company has licensed Denel Asia to manufacture. In the 2015-2016 Denel annual report, Mr. Mancha, as chairperson of Denel, said the following in an attempt to justify the Denel VR Laser joint venture. Denel, and I'll quote, Denel still sees massive potential for growth in the Asia-Pacific region, which will soon command more than half of global defense procurement outside of the United States. At a time when defense budgets are contracting in many countries, Asia-Pacific is expanding and opportunities are opening up for Denel to find new markets for our world-class products, especially in the fields of artillery, armored vehicles, missiles, unmanned aerial vehicles. The establishment of Denel Asia is a joint venture in Hong Kong was done to create a stronger foothold in this region. We are currently looking at various options to address this market. Needless to say, if you look at the state of Denel today compared to what was 10 years ago, they have absolutely ripped it out, shredded to bits, and Denel today is battling to pay their salaries of their employees, where previously they were a very proud organization representing South Africa internationally. I'm done.
Thank you. Just by way of summation, you've presented facts that Denel entered into a joint venture with VR Laser Asia that was ultimately not in the best interests of Denel or the people of South Africa. What are the key facts about VR Laser Asia that made this deal not in the best interest of South Africa or Denel? In particular, VR Laser, as I understand it, had previous dealings with Denel and had been involved with Denel, but the joint venture was with a completely new shell company based in Hong Kong. Is there anything else that you want to add in particular about this company and its ownership that makes it point to corruption or state capture?
The ownership I don't have in front of me, but it is part of the documentation fact. The one scary thing about this relationship is that VR Laser had no history in the Indian subcontinent. That's the first point. Second point is the 100 million rand was given as a loan and not as an investment, which means this new vehicle would have had to repay this 100 million rand with interest. Thirdly, the marketing as well as the intellectual property. Denel South Africa would have had to given the intellectual property, and the value of Denel is exactly in the intellectual property environment.
Thank you. I'd like to move to the role of the National Treasury in the Denel VR Laser transaction, or non-transaction as it turned out. And I'd like to refer to the affidavit of the DG of National Treasury at the time in the litigation between Denel and National Treasury. Now, that litigation arose out of a dispute between Denel and National Treasury as to the interpretation of one of the sections of the PFMA. And they were arguing about the requirements for reporting and how long National Treasury would have been allowed to have to approve or not approve Denel's application. You don't have it before you, but I'd like to read it out into the record because it's a public document in a court file, but not readily accessible. And this is the DG of National Treasury talking about the decisions of National Treasury and their views after they had had a meeting to discuss the Denel pre-notification letter. And he says at paragraph 35, in considering the application, National Treasury had identified a number of key areas of concern for which the information that had been requested by National Treasury was fundamental to be able to properly assess the application. In this regard, the information provided by Denel did not comprehensively address all the issues that had been requested by National Treasury. In addition to new issues that were emerging, this was making it difficult to finalize the application. And he then lists some of the concerns of Treasury. The applicant, that's Denel, had not provided Treasury with any written legal opinion to support their interpretation of the deemed approval by Treasury for the transaction to proceed. In its application for approval, Denel had indicated that the establishment of the joint venture would enable the Denel Group to re-enter the Indian defense market and exploit other defense opportunities in the Asian Pacific region. Denel had initially entered the Indian defense market in 1994. It had, however, been blacklisted since 2005. And Denel had been fined almost $77 million for the contravention of India's legislation. Treasury says, Denel had indicated that these allegations that had resulted in its blacklisting had been thrown out of court, and that the Indian embassy had indicated to it that it may proceed to conduct business in India again. One of the concerns of Treasury is that in its 2015-2016 corporate plan, Denel had not contemplated entry into the Asia-Pacific market. It is not clear what resulted in the change of heart, and no explanation is provided. Denel has only the importance Denel had only stated the importance of the Indian market to its growth strategy. In the application for approval, Denel outlined that the Denel Group had explored the Indian market and that local partners were required in order to operate in India. It is not clear to Denel why certain companies were overlooked by Denel in their review of the market and what led Denel to the conclusion that VR Laser Asia was the most suitable partner for the transaction. In the application for approval, Denel indicated that its contribution to the joint venture would be in the form of its intellectual property, which would enable it to hold a majority shareholding in the joint venture. The remaining percentage would be held by VR Laser Asia. Notwithstanding the request, only a high-level income statement for the joint venture had been provided with the application for approval. The cash flow statement provided by Denel was not comprehensive and was insufficient to allow for a proper analysis. No balance sheet was provided. From the little financial information provided by Denel, it appears that there was a significant cash shortfall in the current 2016-17 year, and it is not clear how this will be met. And this is with regards to VR Laser Asia, who was the company that Denel was going to enter into a joint venture with, take a loan from, and provide access to its intellectual property. And Treasury here is saying it is completely unclear how this company is even solvent. Treasury then points to the fact that Denel had appointed Singane and partners, as well as ENS Africa Forensics, to conduct a due diligence on the joint venture. Those reports were included in the application for approval to Treasury. We have not had access to those reports, but in this affidavit, the DG says the key issues that emerged from these reports, and these are by one of the big law firms in South Africa, was that VR Laser South Africa is currently in a technically insolvent position. It appears not to be in a position to raise the money required to advance VR Laser Asia so as to enable the establishment of the JV. The last few sets of signed annual financial statements of VR Laser South Africa were issued with qualified audit opinions. VR Laser South Africa funds its business operations and capital commitments through loan financing from its shareholders. The shareholders have been identified as politically exposed persons. VR Laser Asia is a shell company registered in Hong Kong and is yet to commence trading. ENS Africa held the view that the statement that VR Asia has an established network of potential business sources which continue to expand may be unfounded. So essentially, what Treasury is saying, in its own views on the documents it considered, and in light of the ENS report, which was a due diligence on the joint venture requested by Denel, was that there seems to be no rational basis for entering into the JV with Denel VR Laser Asia. In conclusion, the DG says, the analysis of the application for approval, this is Denel's approval to Treasury, highlighted a number of issues which needed to be appropriately resolved before the application could be supported. This included the fact that there had been no mention of this deal or an indication to enter into these markets in the corporate plan of Denel in the previous year. There was no sound basis for selecting VR Laser Asia as a partner in the joint venture. The rationale for establishing a joint venture in Hong Kong, as opposed to any other jurisdiction, had not been provided by Denel. And as part of the motivation for the transaction was that it would enable job creation and the advancement of broad-based black economic empowerment. However, this appeared to be misaligned with India's requirements, and the proposal that the applicants sell products at preferential terms, that is, Denel was to sell its products to the joint venture on preferential terms, was not in the best interest of Denel or the government. Ultimately, Treasury, in its view, held that a comprehensive business case and detailed financial projections had not been provided to enable a thorough assessment of the impact of the joint venture on Denel's financial position. However, the information provided indicated that there would be a substantial cash shortfall in the current year. Now, those are the views of National Treasury, and that was one of the reasons why Treasury did not, in the first instance, approve this application. Do you have any comments on those statements by Treasury? Do you agree, in your experience, in the documents you've looked at, do these accord with those documents?
I fully agree with those sentiments. And if you look back and if you look today with hindsight, how the Guptas operate, that's exactly how they operated. And the Freda farm is just one example of exactly how they operate in that environment.
When you say that, do you mean by establishing shell companies and holding shareholding and allowing transactions with government and that are not necessarily commercially sensible transactions?
That's exactly what I mean.
There's one issue I'd like us to just go back to quickly, and you did mention it, but it was the suspension of the executive members of Denel. Can you just explain that briefly? Once the new board was replaced, the board then held fiduciary duties to Denel, and its job was to make sure Denel ran efficiently and effectively. What was the first thing within the first 6 weeks that happened once the new board had been appointed?
What happened in Denel, and if I generalize, it's purely to show the trend with state capture. What happened in Denel happens in other organizations, such as ESCOM, such as PRASA. When you appoint a new board, you replace the chief executive officer, chief financial officer, and potentially the chief procurement officer. What they then do is go out on tender, and you get particular pricing, but the organization that gets the tender submits stuff, and then the value of the tender is increased dramatically. And one particular case that has already gone to court is PRASA taking Sufambo to court. They won, and they've actually overturned the contract with 25 billion rand. And now the fight is on to get the money back. But that's exactly how they do. They inflate tenders, and they under-deliver, inflate tenders, and there are 25%, 30% bribes that get paid in the process as well. So what happened there is just quite normal business for the Gupta family.
You mentioned that OUTA had presented a document to Parliament with some of its findings and the evidence it had in relation to this transaction and its concerns about the interference of third parties.
Sorry. Did you answer the question about what happened within 6 weeks of the new board taking over?
I don't have the evidence right in front of me, but within a very short space of time with the new board, they typically replace the chief executive officer and the chief financial officer and the chief procurement officer. And what that does is the decision maker, those are normally the signatories on any contracts. So what they do is they replace, they suspend them or they fire them, and then they bring people, pliable people in. So they just sign off because these people are brand new, they are not experienced, and they don't understand their fiduciary duties. And that's typically what happens.
Yes, I understood that. So your remarks about the tender and bribes are made in general then?
Yeah.
Thank you.
Sorry, I'll continue with my question. It was that the report that OUTA had given to Parliament detailing some of these allegations and some of the evidence that OUTA had. Can you tell us what was Parliament's reaction and what has happened?
I'd be very careful in my words, but what we've done on 29th of June was submit No Room to Hide, the President Court in the Act. We are not the only people operating in this space, so if I claim credit for this, it's wrong. But subsequent to our submission, there was a vote of no confidence, Parliament took note of the document, and there were 5 subcommittees established to investigate state capture, not necessarily under that name. ESCOM has run for a few months. PRASA is now coming to fruition. The subcommittee on transport have established one as well, and social services would be, there are 5 committees in total, but ESCOM has been the most prominent one up to now. So there are 5 committees established. That's starting to run and continue to run. In addition to that, the state capture inquiry has also now been, but that's not us, that was the public protector. But these things are all coming together now, where we think 2018 will be the year where things starting to turn.
So is there any subcommittee focusing on the issues of state capture in Denel, specifically?
State capture is the one established for Denel. there is one established, but it hasn't been started working yet. The danger exists, and that's come to the fore the last few days, is that Parliament is saying there is a state capture inquiry, so therefore we don't have to launch these things. And the danger with that is that their responsibilities lie and that somebody else take over. And we're imploring Parliament to continue with that work because it's critical for South Africa.
You've given evidence to the panel and the people here today about the chairman of Denel, Mr. Mantashe, who was appointed, and the links he has to the alleged Gupta network. We've seen that there was confidential information from Denel sent to the minister, that the minister's communications to Denel were forwarded on to private third parties. Where's Mr. Mancha now?
He is still chairperson of the board.
What, in your view, apart from the litigation that OUTA has proceeded with, can be done to hold the players in this saga accountable? You've mentioned the subcommittee investigation into state capture in Denel. There is litigation pending with OUTA. Is there anything else that could have been done to prevent this or to stop it happening in future?
We expected Lynn Brown to act decisively and almost immediately to arrest the rot, not only in Denel, but across state-owned entities. In my mind, Mr. Mancha should have been suspended immediately and replaced with somebody else. The Director General of the Department of Public Enterprises should have been suspended. The only person that she acted against was her PA. And everybody around her has been affected in one shape or another. It took other people for the minister to do the minister's work. Even ESCOM, she replaced the board with other poor people. And only in January this year was it done. So I know that the focus of this committee is absolutely on Denel, but the examples and the trend, it's across the board with other organizations. So I keep on bringing other organizations in just to set the scene for that. But in simple terms, she should have suspended the board, she should have investigated the chairperson as well as the Director General of the Department of Public Enterprises.
We've heard evidence yesterday that some of the oversight mechanisms that have been successful in constraining state capture, one of them, Professor Chipkin mentioned, was the High Courts, another was civil society. In the evidence you've provided today, it appears that the role of National Treasury as an oversight of state-owned enterprises has been invaluable and ultimately meant that the VR Asia deal did not proceed.
Treasury is an absolute critical component to ensure that rules and regulations are adhered to, and when and where they find things are wrong, they actually step in and stop that. And I believe that they were one of those critical components, because without them intervening, this deal would have gone through, and billions could have gone lost in this way as well.
I'd just like to highlight one last issue, and that is, and you have mentioned it, but it's the link between Denel's pursuit of this transaction and the change in the cabinet reshuffle, as we now call them, that occurred with the Minister of the Treasury. Can you comment on the timing and Denel's use and how it took advantage of that opportunity?
The previous Minister, Pravin Gordhan, had his finger on the pulse. He was very meticulous when it comes to state expenditure, and he had control, and he controlled the abuses and stuff. And he held it in check. I suppose that's the best word. Almost immediately after his replacement with Des van Rooyen, within 2 or 3 days, a number of things happened, and this submission was done 2 days of him there. He hasn't settled in yet. As a matter of fact, he hasn't met his advisors at that stage, because they were given to him by the Guptas. And immediately he had to, and he was a tool in this process. 5 days later, he was taken out, and I think that the Igaba did not play the role. And as a matter of fact, there was tension between the minister and the officialdom inside Treasury, to such an extent that things actually started going wrong. And the billions that were siphoned off is because of that tension. And people are leaving the organization, which they should not be leaving.
Thank you. That's all the questions from the evidence leaders, unless you'd like any concluding comments, Mr. Theron. Otherwise, we'll hand over to the panel.
Thank you very much, Mr. Theron. Some of this you may have covered, and it's just maybe I didn't pick it up. In August 2017, you laid charges against Mr. Mancha, and I just wanted to know whether there have been any developments from the side of the police.
On the Mancha charge itself, there was very little. We are working with the MPA and the Hawks in other cases, but this case in particular has not got any traction as yet.
So you haven't had anything?
We haven't heard anything yet, no.
Okay. The second question is that you've been to Parliament as OUTA, and you said that the presiding officers have established these or instructed the portfolio committees to do some investigation. And secondly, that we now have a commission of inquiry being set up. And I just wanted, having gone to the police, having been to Parliament with the commission of inquiry, a tribunal like the one that is sitting here, what would you like this tribunal to do?
I would love the tribunal to make very specific and strong pronouncements about the activities that has taken place up to date, the revelations that were made, and just be very strong with regard to the actions going forward. More important than anything else, it's a call on the citizens of South Africa to stand up and reclaim their rights as citizens.
All right. Thank you very much.
Thank you, Mr. Theron. Can you just remind us again what the requirements of the Public Finance Management Act is for a joint venture such as this? It requires a prior approval of which ministries, for instance?
Everyone would be area specific. When it comes to the arms deal, cabinet must be involved because the arms deal is very specific. In any other organization such as PRASA, when it comes to joint venture for building trains, it does not have that high level of security and approvals. But typically what happens is that an organization such as DPE, using this as a general, not a particular arm, the Department of Public Enterprises would develop a case, and it normally have a 3-year lead time because you have multi-year planning taking place, and you go to Parliament and say, in this next year, the next 12 months, we will be doing A, B, C, and D, in this case, going into the Indian market, because you declare that to Parliament. Once you develop that, you start talking to Treasury about the legislation, the legalities, and in this case, the state advocate will also get involved to make sure all those things happen. In this case, nothing of those has happened until right to the end when they requested Treasury for approval. And Treasury said, no, there's not enough information, there's dangers involved for the company as well as for Africa, and that was halted.
Thank you. Thank you.
This means, of course, that the whole of the cabinet, or all the cabinet members attending a meeting at which the approval was given, are actually responsible for the manipulation. Do you agree with that?
I don't think cabinet has been, this document has gone to cabinet. We couldn't find evidence of that. So in this case, cabinet would be innocent. But if it had to go to cabinet and they
But shouldn't cabinet, look at the names and have them checked out, see whether they have enough experience, see what they can offer, or is cabinet doing its job if it just takes the recommendation of somebody without looking carefully? I mean, one assumes that cabinet members know what they're doing, and they just don't, they read the papers before them, and they make the necessary inquiries before approving things. Or is our cabinet a rubber stamping mechanism?
My apologies, I misunderstood the question that you asked originally. When it comes to cabinet appointments, board appointments, it has to go to cabinet. And it's cabinet's responsibility to ensure that the people that they approve have the qualifications, experience as a whole to at least be able to do the job, because somebody would be a lawyer and somebody would be technical, and together they will then form things. In this case, we believe, and in a number of cases, Cabinet has failed this country.
So the real point is that without an element of control by capital over responsible political role players, the kind of capture you talk about is quite impossible.
I agree.
Thank you very much. Your report was very interesting and illuminating, the written one in particular, which we will obviously have regard to in the ultimate analysis. Thank you very much.
Member Chair, may I just make two comments, not as a witness, but in my role as evidence leader. Perhaps just to add to the response to Member Pilay's question, specifically in respect of the Denel VR Laser Asia transaction, the PFMA requires at Section 51 that the accounting authority of a public entity, which is the board, must promptly inform National Treasury on any new entity which that public entity intends to establish, or the establishment of which takes the initiative, and allow the National Treasury a reasonable time to submit its decision prior to formal establishment. So there in particular, Denel was required to get Treasury's explicit approval for the establishment of a joint venture. And I just want to note, and it's apparent from the affidavits in the bundles, that Denel waited 30 days, and those 30 days were passed through the December holiday period, and thereafter just proceeded to implement the transaction, saying...
Yes, and there's a difference of interpretation of that section anyway.
Indeed. But that is the situation with the PFMA obligations.
Thank you, I
Thank you.
appreciate that.
Before you call the next witness, there's one issue I'd like to raise with you. It was very worrying to me that whistleblowers declined to give evidence. I would like to know, as soon as you can tell me, whether the terms of reference that require protection of this category of witness were employed, and whether that protection was actually offered. And if the protection was offered, I would like on record the terms on which the protection was offered.
Thank you.
Thank you.
I will take instructions and inform the panel.
Thank you.